Ladies and gentlemen, good morning. Welcome to American Law webinar series by Lehrmach. Lehrmach is an intellectual property rights consultancy. This is Uwe Lee, your presentation host. Today's presentation is the 1996 WarnerVision Entertainment case, vesting on USPTO trademark priority registration with intent to use filing. U.S. trademark commands two distinct doctrines. First doctrine, an unregistered trademark is automatically recognized by federal government so long as it is used in commercial operations with limited rights since it has not been formally registered with U.S. Patent and Trademark Office, or USPTO. Second doctrine, when trademark is formally registered with USPTO with appropriate fee payments, of course, it is then lawful constructive notice to all like-minded competitors that a specific trademark is now recognized by federal government for nationwide commercial usage. However, there may be times by which a business entity desires to register the trademark but is not yet commercially prepared for nationwide usage. In other words, they need to reserve the trademark until business logistics are mature for operations. In this manner, USPTO offer intent to use, or ITU filing, with its own separate fees, which enables business entity to establish a priority date or priority usage for the trademark to be used in the future, without the requirement to engage in commercial operations, that is, the selling of goods and services designated by the trademark. Of course, given its nationwide implications, this ITU is accompanied by, quote, sworn statement of bona fide intent to use the mark, unquote. However, this clashes with trademark's first doctrine of being recognized when used in actual commercial operations. For this case, it is further complicated by a rival commercial usage of the same trademark without registration, then selling the same unregistered trademark to another rival. Therefore, court case acknowledged ITU by itself does not grant trademark registration immediately. However, it does secures applicants' right to leap ahead of other rival competitors' mark usage, since federal USPTO commands priority constructive nationwide notice of all trademark usage. Trademark will only be formally registered after applicants demonstrated actual use in commerce by filing a statement of use with USPTO, accompanied by its own fee, of course. Notice the multiple fee schedules involved. Number 1, trademark registration. Number 2, intent to use, ITU. And number 3, statement of use, SOU, or actual commercial mark usage. Thus, devil is in the details. Onward to our WarnerVision case.